Hello, defense attorney Mark Rosenfeld here. One question I get, not too often, but I do get, is what is a federal driving under the influence case? And a federal driving under the influence case has very many similarities to a regular state DUI and many differences. But a federal DUI is one that is the federal government has jurisdiction. So it takes place on federal land. That may be a national park, it may be a military base, but it has to be a federal installation or federal land where the driving took place and the alleged DUI took place. And if that's the case, we would be dealing with the DUI case in federal court. And for many purposes, this is a very formalized process, much more so than state. It is a Class B misdemeanor with exposure of up to 6 months. So even on a first DUI arrest on federal land, the person is looking at possible federal prison, but there are ways to avoid that. There may be deals or other alternatives that are set up, but it's important to know that the exposure is up to 6 months. As a 6 months exposure in federal court, you do not have a right to a jury trial. Therefore, it would be a federal judge who is deciding the evidence and whether the prosecution has proved beyond a reasonable doubt that the person was in fact driving under the influence. Now, with the federal jurisdiction, the court procedures are more formal and they're different. Instead of using the state rules of evidence, we're using federal rules of evidence, which are similar, but there are differences that you need to know about. And being with the formal federal rules of evidence, we need to interpret or view the case through those rules of evidence to see what would come in and what would not come in. It's also important to note in the beginning of the case, usually at the first court appearance, there will be like an additional booking process where the person who's charged with the crime needs to be interviewed and be booked and processed to make sure that the federal government has all the information that they want from the person, which may not have been obtained out in the field when the arrest took place. So the rules of evidence are a little bit different. The law is also a little bit different when it comes to driving under the influence for federal purposes. In California, it is a driving state, which means that the person must be driving while under the influence. And if they're just sitting in their car parked in a driveway, that's not considered driving in California. However, in the federal jurisdiction, it's actual physical control of the car. So if the person was drinking in their house and they went out to the driveway to listen to music in the car, then they got stopped or someone came to do a welfare check and it was determined that they were impaired for purposes of driving. Under the federal rules, just being in the car with the keys behind the wheel is in actual physical control of the car and could be a DUI given those circumstances. So the rules of evidence are a little different. The rule of law is a little bit different. What is the same from state to federal is the science of how alcohol affects the human body, rising, falling blood alcohol level, potential contamination issues. All of those scientific defenses still exist and could be argued to a judge in federal court. Now, most cases in state court or federal court are going to resolve through settlement or plea bargain negotiations. Again, in the federal system, this is a more formalized process, but it still does exist where you can negotiate with the prosecutor to see what the appropriate charge is and what the appropriate punishment would be, and then the prosecution and the defense can make that recommendation for settlement to the judge. And usually the judge is going to agree and go along with it. Sometimes they don't, but most of the time, if the prosecution and the defense agree to a charge or a sentencing range, the judge is going to go along with it. Now, not all cases, most cases are going to settle, but not all cases are going to settle. And there are various reasons why a DUI case may not settle. There may be problems of proof, there may be collateral consequences that could affect the person, and then you have a right to a trial in front of a judge. These are usually relatively short. In Los Angeles in state court, a DUI trial could easily take 5 to 7 days. In federal court, because you're not going through the process of picking a jury and you have an actual court date that's set for trial. Things are going to probably go the entire day. Things are going to go much quicker in federal court, and a trial in federal court may take 1 or 2 days to complete. So that is an option in appropriate cases. If you've got questions about federal DUIs, give me a call. Once again, this is Mark Rosenfeld. I practice in Southern California. My office is in Beverly Hills, and you can reach me at 310-424-3145, 310-424-3145. Take care, be safe.